And could you please introduce yourselves?
Thank you for allowing us to testify before you today. We are a unit composed of juniors and sophomores from East Grand Rapids High School. I am Ella Georgievsky.
I'm Jack Lato.
I'm Lauren Bentley. We are coached by Adam Horos and Benjamin Langholtz, and we are Unit 5.
Well, thank you very much. Today, we are going to talk about question number 1. A result of the decision Wisconsin versus Yoder is that, quote, any parent guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs. Do you agree or disagree with the result of this decision? Why or why not? What words, if any, are found in the US Constitution or in state constitutions that protect the right to an education? How have courts balanced religious beliefs with other rights? You may proceed. Thank you.
Justice Douglas shared his dissent of Wisconsin v. Yoder by emphasizing that if he is harnessed to the Amish way of life by those in authority over him, and if his education is truncated, his entire life may be stunted and deformed. This lone dissent is more relevant today as high school education holds substantially more weight. In our current society, the government has a compelling interest to ensure all children have a basic education, which gives individuals the skills to survive in a modern economy, as Justice Breyer stated. When Yoder was decided in 1971, a high school diploma opened doors to new careers. Today, it is essential for fruitful employment. Giving Amish children a high school education would not only grant them this gift, but could be done while still allowing them to practice their religious lifestyle.
When first introduced into the United States, compulsory education's primary purpose was to protect children from parentally imposed child labor. The decision in Wisconsin v. Yoder opposes this standard by not favoring the interests of the children, but instead placing sole power into the hands of their parents. Justice Rutledge asserted in Prince v. Massachusetts that the family itself is not beyond regulation in the public interest as against a claim of religious liberty. Allowing this large religious exemption deprives children of the possibility to participate fully in society, thus placing Yoder's removal of child autonomy in a disenchanting light.
The right to education is a freedom that is gaining value as it has become a societal necessity for success. However, our Constitution does not reflect the ever-increasing importance of education. Justice Powell in San Antonio v. Rodriguez stated, education is not among the rights afforded explicit protection under our federal Constitution. Instead, it is arguably implied in the Equal Protections Clause of the 14th Amendment, as no state shall deny to any person within its jurisdiction the equal protection of the laws. The 14th Amendment attempts to do what the Constitution does not in establishing a clear basis for equal education for all. But as education laws vary by state, the rights granted are not consistent and therefore not always equal.
Although education is largely absent from our national constitution, it is present in 22 state constitutions as a guaranteed right. As stated in Brown v. Board of Education, education is perhaps the most important function of state and local governments. These smaller governments are closer and more receptive to the people, therefore better equipped to handle education. The Michigan Constitution asserts that every school district shall provide for the education of its pupils without discrimination as to religion, creed, race, color, or national origin. These words not only ensure education for all students, but specifically an education not subject to discrimination and instead equal.
The balance between religion and other fundamental rights has been a subject of much controversy throughout history. In the 1879 case of Reynolds v. US, the court found people's right to practice religious polygamy could be limited. This established a general precedent that we are free to believe, but not always free to practice. Later, Sherbert v. Werner instead ruled on the side of religion, valuing free exercise, placing laws restricting the citizenry's exercise under strict scrutiny. This was again changed in the landmark case of Employment Division v. Smith, in which free exercise was placed lower on the scale of importance, subjecting it to rational basis, unless another right was also threatened.
This, however, did not settle the debate between religious beliefs and other rights. Throughout the COVID-19 pandemic, the government imposed severe restrictions to protect American lives. Religious organizations were included in this shutdown, but were slow to be afforded the freedom to reopen as quickly as the entertainment industry. In Roman Catholic Diocese of Brooklyn v. Cuomo, it was stated, the loss of First Amendment freedoms for even minimal periods of time unquestionably constitutes irreparable injury, indicating an unequal application of the law. On this basis, the case was decided in favor of religious liberty and was overturned to allow indoor meetings in select, lightly infected regions. Religion is a hallmark of the United States, serving not only as endorsement to its liberating founding, but also its democratic future. Thank you. We are now ready for your questions.
Oh, well, thank you. And I think I'll just pick up exactly where you left off. So with this pandemic and religious freedom, in California, Governor Newsom, among many other restrictions, placed a ban on household gatherings of more than 3 families during COVID. But like other states, allowed people to go to grocery stores and shopping malls. And it was a neutral ban on its face, not targeting religion, but certain religious individuals, because they could not gather together for Bible study or prayer, sued the governor of California, claiming violation of religious liberty. How should the court analyze that case, and who should win?
When approaching cases that have to do with religious freedom in our country, I like to look back at the case of Sherbert v. Verner. In that case, it was stated that the court needs a compelling state interest and least restrictive means to rule on restricting religious practice in our nation. And in this sense, I believe that is a very fair way to look at these cases, because each are very individual, and the exercise people need to be allowed in order to fulfill their religious varies depending on which religion they choose to practice. So in this case, I believe we need to weigh the government's compelling interest with the specific value of those individuals' religion.
I would say that the people practicing the religion should win, because the court has ruled in cases such as Church of Lukumi Bible Library, City of Hialeah, that if someone's if it is specifically targeting another religion, and even if people can still practice their religion. So I believe that the citizens of California should prevail and should still be able to practice their religion.
So in this case, the law did not target religion. It said there can't be any in-home gatherings of anybody for any purpose. So it was neutral on its face. So that's different than City of Hialeah.
That is fair. And in the City of Hialeah, it was not neutral. So in this case, it wouldn't specifically apply, but I think we do stand by our position that every case is different. And in this specific case, we would still need to revert back to weighing the government's needs and that of the people.
But
it's important to note that in intent, the law might have been neutral, but in execution, it might not have been neutral, therefore placing an undue burden on these religious practices. And also, these people are choosing to attend things such as Bible studies, so it is their personal choice.
Great. So I have a different hypothetical. The Yoder case related to not allowing, the Amish belief that students didn't have to go to school after 13. What if there was a religious sect that had as their religious belief that girls of any age did not need to go to formal schooling because they were being taught just fine in their religion? How do you think, or how would a court look at that issue? And would they look at it any different perhaps than Yoder?
I believe that, of course, issues of equality are very important in our nation. As we look at our 14th Amendment and our Equal Protections Clause, I think, if anything, it would heighten the issue, but I'd still think it would bring it back to those same origins. When we carefully chose our position in disagreeing with Yoder, we really focused on this ideal that education is really important. It's a landmark for our nation. And if you look at our nation's history, through cases like Prince v. Massachusetts, we have enforced compulsory education to avoid child labor. And although the Amish are not directly imposing child labor on their children specifically, I think it alludes to the idea that those children are not receiving education. And so in that similar sense, those females who were then not only discriminated would still not be receiving that same education as the Amish children.
I also believe the court would look at this specific case differently, because it does have to do specifically with gender and gender equality. And in this sense, I think we have granted women equal rights in other things, such as in the case of Minor v. Happersett, granting women the 19th Amendment. And so I think we should apply that here and give equal protections to education for all, regardless of gender or race or any other weighing factors.
I think this is similar to our position, because that the courts would oppose this, because all women should have the opportunity to kind of have any career that they desire, and by even if it's against their parents' religious beliefs, I feel that the child should have the autonomy to follow their dreams in their career.
Let me follow up with that. If the child should have that autonomy to pursue their dreams and careers, so a quality education, and one of you said religion should win. How do you balance it where the parents have that responsibility for the well-being, the welfare of the child, and if their religious beliefs sort of conflict with the child's decision to pursue a certain educational path?
Well, in this specific case, when you look into the Amish religion itself, at the age of 16, Amish children embark on this journey called Rumspringa. And in Rumspringa, they go out into the general world and they are able to observe those practices. And then from that point on, they're able to make the decision of whether or not they want to continue being an Amish individual. And so our argument is not to invalidate religion or to, I guess, dissociate the children from their parents at all. We believe that that right is very important and the right to parenthood is important. But we also believe that the decision, although made before the children is 18, is going to affect them long term and that they should be advocates in that decision for themselves.
Do you think 16 is a good age for them to be able to make that determination?
Due to the Amish religion having Rumspringa at 16, I do believe that is a solid age. It does vary state by state though, and some states are 16, some 17, and some 18. I personally would agree it would be 18 because that would be the edge at the end of high school education. And from that point on, students have a GED and they can go out into the world and choose whether they want to pursue higher education or still be able to be employed.
I believe that 18 should be the right age, because if the kids were taken out at 16, if the parents were still allowed to take them out at 16, then they still wouldn't have that high school education that they need to survive, as just Breyer stated in U.S. v. Lopez, to survive in a modern economy. So saying that if 18 was required, that would give them the best opportunity to survive in a modern economy.
I would have to disagree with my colleagues and say that the dropout age should remain 16 or up to the states. Because in providing those 2 years, you are providing a substantial education in order to make that decision for themselves. And so therefore they should retain the right to drop out at 16. And as society has developed, now you can get a job without a high school diploma. Many of their core requirements are just 16. So I think that decision should be left up to the teenager and should stay at 16.
And what would you all say would be, what would you say would be your constitutional reasoning? What rights are being protected if a child was to leave at 16? What's the constitutional reasoning behind that?
The constitutional reasoning would be at 18, we are adults, but before that, we are minors. But in that sense, we do have a promise through things like Princeton, Massachusetts, to protect our youth, as the youth are our future. And we thrive in a democracy, and in a democratic nation, as Thomas Jefferson once said, we cannot be both ignorant and free. And so if we are, please finish my statement. If we are not educating our youth, we are not preparing our democracy up for a future to thrive and to succeed. And so that is why we believe constitutionally this needs to be protected.
Congratulations, very well done. Congratulations not just to the Unit 5 team, but to the teacher and the coach. Thank you very much for that wonderful presentation. And now the judges will give you some feedback.
Well, what a spectacular job. Warmest congratulations. Very thoughtful and intelligent and sophisticated analysis. And we heard some things from you that we have not heard from any other team. And your approach was very unique to say, even if Yoder was correctly decided in 1971, the facts have now changed in that a high school education is very different today than it was in 1971, and therefore the constitutional analysis needs to reflect that fact. And because this is a balancing test of constitutional analysis, the weight of factors are different than they were then. That's a very powerful and very sophisticated argument, and I really liked it a lot. And I also really liked in your questions and answers, you kept coming back to strict scrutiny and saying, okay, let's look at these problems through the lens of, is there a government, is there a compelling state interest? Is it narrowly tailored? What are the various interests? And that was really smart. I also, this was the first time we heard Rumspringa. So that was excellent as well. So spectacular job, warmest congratulations. Really enjoyed it and also learned a great deal from it.
Thank you so much.
I agree. I think you guys did a really, really great job. And I think that, did you guys all say that when you were sophomores and juniors? Right? So I think that kind of that's fantastic because, you know, you're not at the end of your high school career, you know, and you guys did a fantastic job. Like Matt mentioned, you know, hearing new information at this point in the day is amazing. Because you all have you know, brought up some extra points. I like that you mentioned you had done your research on other state constitutions. So you mentioned about the states, and I love the quote. I had forgotten it, that we are free to believe, but not always free to practice. I thought that was great and it's very relevant. So good job all around.
Thank you.
I concur with my colleagues. Excellent analysis and excellent application. The one area of disagreement with you is that 16 years is not yet the age. They're still considered juveniles in the law. And so we haven't fashioned laws to allow 16-year-olds to function as adult, but you have taken an interesting approach. I look forward to the differences you will make, not only as you approach your senior years, but as you advance your career paths. You'll make a major difference in what happens, not only in your home state, but throughout our country. Well done. Very impressive. Thank you.
So much.
Thank you.
Thank you guys all so much.
Thank you.
You.